stop everything right now. On 5 March 2026, the UK government published one of the most sweeping sets of immigration rule changes in years. And the shock is not just what changed, it is how fast it changed, how many people it affects, and how little warning most migrants received. Skilled workers, students, asylum seekers, long-term residents counting down to settlement, travelers from countries that never needed a visa before, people with digital immigration status who thought they were safe. All of them woke up to a different set of rules. And if you are in the UK on any kind of visa right now or planning to come to the UK in 2026, what you hear in the next few minutes could be the most important immigration update you have ever watched. The UK's immigration system has changed more in the past 12 months than it did in the previous decade. The 2025 Immigration White Paper set the direction, and 2026 is the year that direction became reality. On 4 March 2026, the Home Office published Statement of Changes HC 1691, a document that introduced simultaneous changes across multiple visa routes, asylum rules, travel requirements, and settlement pathways. It is not a single change. It is a package of changes, each one significant on its own, and together representing a complete reshaping of how the UK manages immigration. The Home Secretary announced several of these changes in a parliamentary statement on 2 March 2026, just days before the formal publication. Some took effect immediately, others are rolling out across April, May, and beyond. And some, like the proposed extension of the ILR qualifying period from 5 years to 10 years, are still being finalized, but are scheduled to begin taking effect from April 2026. If you are on a skilled worker visa, a student visa, a family visa, an asylum route, or any other UK immigration route, this video covers everything you need to know right now. We are going through the 7 most significant changes one by one, what they mean, who they affect, and what you must do immediately. The first change is one that has already caught thousands of people completely off guard and is already causing real problems at airports and train stations. From 25 February 2026, the UK's no permission, no travel policy became fully enforced. Under this new system, airlines, ferry companies, and international rail operators are legally required to check your immigration status digitally before you board. If the Home Office systems cannot confirm that you have valid permission linked to the specific passport you are presenting, you will not be allowed to board. Full stop. No exceptions. No opportunity to resolve it on arrival. The significance of this change is enormous for a very specific group of people. Those with the visas and those relying on digital status under the EU settlement scheme are most at risk. And a visa is a digital immigration record. It is not a physical stamp in your passport. It is not a vignette sticker. It exists entirely in a Home Office database. And that digital record must be linked correctly to the exact passport you are using to travel. If you recently renewed your passport and did not update your UKVI account to link the new passport to your e-visa, the system may not recognize you as having valid permission. Dual nationals are particularly vulnerable. A British citizen who also holds a foreign passport and who travels on the foreign passport may find their permission check fails because they are actually expected to travel on their British document. British children born abroad are also in this category. If a child is legally British but does not hold a British passport and travels on a foreign passport, the ETA linked to that foreign passport may not be valid for a British citizen. The rule is immediate, it is being enforced, and the consequences of getting it wrong are that you do not travel. The second change is one that will directly affect employers, recruitment teams, and thousands of workers currently on skilled worker visas. From 8 April 2026, the rules on how salary compliance is assessed for sponsored skilled worker visa holders are changing significantly. Previously, the salary threshold was assessed on an annualized basis. From 8 April 2026, the rules require salary compliance to be met in each individual pay period and also across specific averaging windows. What this means in practice is that if your pay varies month to month, if you receive variable bonuses, commission payments, or if your hours fluctuate, your sponsor must now be able to demonstrate that your salary meets the required threshold in each pay period, not just on average across the year. For workers on standard salaries with no variation, this change is straightforward. For workers whose pay includes variable elements, there may be compliance implications that neither the worker nor the employer has fully prepared for. Sponsors who issued certificates of sponsorship before 8 April 2026 benefit from transitional arrangements and are not immediately subject to the new rules. But for any new applications and for ongoing compliance monitoring going forward, this is a critical change that every sponsored worker and every sponsoring employer must understand. The third change affects students and, through the student route, the integrity of the broader immigration system. From 26 March 2026, the UK government implemented what it calls a visa break. This is a temporary suspension of the issuance of sponsored student visas to nationals of 4 specific countries: Afghanistan, Cameroon, Myanmar, and Sudan. In addition, nationals of Afghanistan are also temporarily banned from receiving skilled worker visas. The government's stated reason is concerns about abuse and system integrity. The Home Office data cited in its own impact assessment shows that the break is estimated to prevent 4,300 student visas and 90 skilled worker visas from being issued during the period it is in force. The government estimates this will also result in 1,300 fewer asylum claims from people who arrived on student visas and 90 fewer from those who arrived on skilled worker visas. For universities and colleges that have already made conditional offers to students from these 4 countries, this is a serious operational problem. For employers who have been recruiting from Afghanistan under the skilled worker route, any pending visa applications or planned hires are now directly affected. The break is described as temporary and will be reviewed regularly, but no specific end date has been confirmed. Universities and employers in affected sectors should seek immediate legal advice on whether existing offers, admissions, or certificate of sponsorship assignments are salvageable under any available route. The fourth change is about refugee status and asylum, and it represents one of the most significant shifts in UK asylum policy in years. From 2 March 2026, all individuals who have their asylum claim granted on or after that date will receive permission to stay in the UK for 30 months, not 5 years, as was previously the standard. At the end of those 30 months, the Home Office will review whether the individual's country of origin is now considered safe. If the country is deemed safe, the individual may be required to leave the UK. The government has described this as a move from an assumption of permanent protection toward a model of basic and temporary protection. It represents a fundamental change in what refugee status in the UK actually means for the people who receive it. Previously, a refugee status grant was effectively a pathway toward long-term settlement and eventually British citizenship. Under the new rules, it is a temporary stay of 30 months subject to review. The Home Secretary confirmed this is part of a new core protection offer that accompanies wider reforms to the asylum system. Additionally, the further submissions process has been reformed. Anyone who has had an asylum claim refused and wishes to submit further representations must now attend an in-person appointment at a Home Office service and support center. This removes the ability to submit further representations remotely or by post, creating a practical barrier that legal charities and asylum support organizations have described as deeply concerning. The fifth change affects travel and will catch out visitors and business travelers from 2 specific countries who had no prior warning of their status changing. From 5 March 2026, nationals of Nicaragua and St. Lucia have been added to the UK visa national list. This means that people from these 2 countries can no longer travel to the UK using an electronic travel authorization. They now require a full visit visa before traveling. The transition arrangements are narrow. Nationals of these countries who submitted an ETA application before 15 GMT on 5 March 2026 can continue to use that ETA until 16 April 2026. After that date, a full visa is required. For anyone from Nicaragua or St. Lucia who had planned travel to the UK in March, April, or beyond, this is an immediate and urgent problem. Visit visa applications take time, require documentation, require a biometric appointment, and must be planned in advance. Additionally, the transit without visa scheme has been abolished. Previously, certain passengers could transit through UK airports without obtaining a visa if specific conditions were met. That option no longer exists. Any passenger who required transit rights and relied on the Transit Without Visa scheme must now obtain appropriate permission before traveling through the UK. The sixth change is about the global talent visa route, and unusually for a climate of restriction, it is an expansion rather than a tightening. From 8 April 2026, the global talent visa route will include a new design endorsement pathway. This is specifically aimed at individuals who are recognized leaders or emerging leaders in the design sector. The design field has previously not had a clear, dedicated endorsement route within the global talent visa, and this change creates a formal pathway for outstanding designers to come to the UK and access the accelerated 3-year settlement route that the global talent visa provides. In addition to the design endorsement, the global business mobility routes are being amended to reduce the overseas employment requirement, broadening the pool of employees who can be assigned to UK projects under these routes. For highly skilled workers in design and creative industries, this is genuinely positive news. The global talent visa remains one of the most flexible routes in the UK immigration system, offering the fastest path to settlement for those who qualify. The seventh and arguably most consequential change is the one that has generated the most public anger, the most legal commentary, and the most parliamentary debate. The extension of the qualifying period for indefinite leave to remain from 5 years to 10 years for most migrants is scheduled to begin taking effect from April 2026. The public consultation on the proposed earned settlement framework closed on 12th of February 2026. The Home Affairs Select Committee is holding an ongoing inquiry. A petition calling on the government to retain the 5-year route gathered over 241,000 signatures and triggered a Westminster Hall debate on 2nd of February 2026. But the political direction is clear. The changes are coming. The exact shape of the new earned settlement system is still being finalized, but the framework as consulted upon sets out a tiered system. Most migrants on work visa routes would face a baseline wait of 10 years. Migrants in highly skilled roles at RQF Level 6 and above could qualify in 10 years. Migrants in medium-skilled roles below RQF Level 6, including many roles formerly on the shortage occupation list, could face 15 years. The 10-year-long residence route, which previously allowed migrants with a complex mix of lawful and unlawful residents to aggregate time towards settlement, is proposed to be abolished entirely. This affects people with gaps, people who overstayed briefly, and people who moved between visa categories over many years. Family members of British citizens, Hong Kong BNO visa holders, and global talent visa holders are among those most likely to retain the 5-year route. But the vast majority of work visa holders face the new system. And critically, the changes are explicitly intended to apply to people already living in the UK who have not yet received ILR. This retrospective application is the aspect that has caused the greatest distress among migrants who made long-term life decisions based on the existing 5-year promise. Anyone who has been in the UK on a qualifying visa route and who is approaching 5 years of continuous lawful residence should speak to a qualified immigration solicitor immediately. Applying before the new rules take formal effect in April 2026 may still be possible for people who meet the existing requirements right now. Delay is not an option. And looking at the broader picture, what 2026 represents is a systematic tightening of the UK immigration system across every entry point simultaneously. Entry is harder. Student routes are more restricted. Asylum protection is shorter and more precarious. Long-term settlement is further away for most migrants. Travel from more countries now requires a full visa. Digital status verification is being enforced in real time at the boarding gate, and the language requirements for skilled and professional visas have already risen, with the English language requirement increasing from B1 to B2 for new skilled worker, scale-up, and high-potential individual visa applicants from 8 of January 2026, ahead of a broader expansion of the B2 requirement from March 2027. The immigration health surcharge, which migrants on most visa categories must pay upfront for the entire period of their visa, remains at $1,035 per person per year for most applicants and $776 per year for students, youth mobility scheme applicants, and children under 18. These costs compound the financial pressure on migrants at every stage of the immigration pathway. What is happening to UK immigration in 2026 is not a single announcement, a single headline, or a single rule change. It is a systematic and sustained redesign of who the UK allows in, how long they can stay, and on what terms they can remain permanently. For some people, specifically those in the highest skilled, highest earning categories, the system is actually becoming more accessible. For the majority of migrants, it is becoming harder, more expensive, more precarious, and more uncertain than it has been in a generation. The people who came legally, worked hard, paid taxes, and trusted the 5-year promise are now being told that promise is changing around them. That is not a small thing. It is a life-altering thing, and the worst response to it is to wait, hope, and assume that it will not affect you personally. The time to act is now. If you are on any UK visa route and approaching a settlement eligibility date, call an immigration solicitor this week. If you have an e-visa and have not updated your UKVI account to link your current passport, do it today. If you are a sponsor with variable pay arrangements for skilled worker visa holders, review your compliance position before 8 April 2026. If you are from Nicaragua, St. Lucia, or you know someone who planned to transit through the UK, get visa advice immediately. And if you found this video useful, share it with every person in your life who is living, working, or studying in the UK. The people who need this information most are the ones who have not yet looked for it. Leave your questions in the comments below. Subscribe to this channel for every update as the rules continue to evolve through 2026 and beyond. We will be here with the facts, the clarity, and the guidance that protects you and your family.